Hey everyone. Hi, welcome. I'm Jordan Ahlers-Smith of the Speaker Law Firm. I am an associate at Speaker Law Firm. Normally Lisa Speaker is the one heading these webinars, but she is off on spring break, so it's my turn to be in charge. I'm an associate here, as I said. My practice largely focuses on family law appeals, mostly appeals involving child custody issues and child welfare issues. I am joined today by Mr. Ashish Joshi. He is the managing partner and owner of Joshi Attorneys and Counselors Firm, located in Ann Arbor. He has counseled and represented clients in state and federal courts across the United States, as well as internationally. Ashish focuses largely on the intersection of forensic sciences, human rights, and complex disputes in situations involving severe parental alienation and psychological maltreatment of children. Mr. Joshi is also a prolific author and has published several articles, including one article very recently in the Michigan Family Law Journal. So if you are a member of the family law section, be sure to check that out. And Ashish and I are going to be discussing all things parental alienation today. So Ashish, thank you so much for joining me.
Thank you, Jordan. Pleasure to be here.
And just before we get things kicked off, there are obviously a lot of participants here today. If you have any questions as Ashish and I are talking, please feel free to put them in the Q&A portion. And I will be monitoring the questions as we're going through. So if you have a question and don't want to save it until the end, please feel free to drop it in the Q&A box and I will get it up and hopefully answered as quickly as I can. So again, thank you so much, Ashish, for joining me this afternoon. I just kind of wanted to start with a basic overview of parental alienation, what it is, the motivations of alienating parents, just kind of the basic building blocks before we start kind of getting into deeper topics here.
Sure. Parental alienation, when we are talking about the phenomenon in the family court's perspective and from that vantage point, it refers to a mental condition in the child, usually one whose parents are in the middle of divorce or separation, and who has aligned with one parent and has rejected the other parent without legitimate justification. And that's a broad definition and very simplistic one of parental alienation as a phenomenon. But what is important to note, Jordan, is often people make assumptions that just because a child is resisting contact with a parent or has rejected a parent, it must be a case of parental alienation. And that's something that needs to be taken care of because you can't make assumptions. You need to have evidence of what is known in the field as parental alienating behaviors.
And I know that you, as I'd mentioned, you recently published an article in the Michigan Family Law Journal discussing specifically the Cadence Law legislation. And in your article, you talk a lot about how there is, this concept where parental alienation can be seen as abusive to a child. Is all parental alienation abusive? Is there a line that we're drawing? Where in your mind do you see kind of that divide?
So first of all, there's a difference between parental alienation, which is a state of affairs or a psychological status quo, let's say, and parental alienating behaviors, which is actual conduct, errors of commission and omission. Evidence of alienating behaviors may or may not lead to parental alienation. For example, you might have a situation where there is significant evidence of alienating behaviors by one parent. Let's say parent A has demonstrated significant alienating behaviors. However, parent B, who is the target of these behaviors, continues to have a decent, normative, healthy relationship with the child. Now, that does not mean we simply sit back and let that continue. It does need intervention, but it may not be a case of parental alienation from a classic sense. There could be many reasons behind it. The child's bond with the parent B, the child's resiliency, the child's age, and cognitive and psychological makeup. So we have to differentiate between the two. But in generally speaking, parental alienation can be mild, moderate, or severe. And here we are talking about the effects of alienation on the child. Could be mild, where the child continues to see the targeted parent, continues to have contact with the targeted parent, but there is a distinct lack of engagement. There is a distinct amount of tension in the relationship. The child continues to say things or do things that gives the other parent a pause as to where is the child getting the information from. For example, the kid comes home to mom and tells the mom, well, you are the reason our family broke up. You don't pay enough child support. If you were paying enough child support, dad and I could go on a vacation together. Or things like that, which gives you some pause about the child being privy to some information that is not appropriate. Compare that to a severe case of alienation, where the child hath demonstrated a pathological hatred for the parent. The child refuses to call the parent as such as mom or dad, calls them Susie or Mike, uses profane language, absolutely just flips out if even the parent is in the vicinity of the child. So you see those very severe behaviors in extreme cases of alienation. And there are no findings of any abuse or neglect on the part of the parent who's being rejected. That is also important to note. So it could be mild, could be moderate, it could be severe, depending on the case and the facts that we have.
Yeah, and I think it's one of the things we talk about a lot with parental alienation, obviously, is the difference between the alienating behaviors and the actual alienation itself. And I think a couple of things that you mentioned there are obviously large red flags. If we're maybe only seeing one or two of those, would that be something that we would even qualify as parental alienation? Is there potentially something else that it could be? I'm kind of leading towards, I was reading your bio earlier and I noticed a term that I wasn't super familiar with, which is child psychological maltreatment.
Mhm.
So I don't know if that's something that you could maybe discuss the difference between, just because, as I said, it's a term that I'm not super familiar with. So if obviously it's on your bio, so I would hope that you're an expert in it.
Well, I don't know about being an expert, but I'll certainly be happy to talk about it. So when we talk about parental alienation and child psychological maltreatment, it's considered to be within the broader umbrella of family violence. Family violence can consist of domestic violence, interpersonal violence, coercive controlling behaviors, parental alienating behaviors, child psychological maltreatment, and other kinds of behavior as well. One of the problem with the term parental alienation these days is that it's in the overkill zone because of the term's prolific effect in social media. I mean, you see people sometimes using that term without facts backing it up, or prematurely, or sometimes conflating some of the facts with alienating behaviors when they're not alienating, but they do require some sort of intervention and acknowledgement from the court. When we talk about child psychological maltreatment, we are talking about typically four different things. And it could be interrelated. It's not mutually exclusive. There's an overlap between these four as well. So we are talking about enmeshment, which is also known as pathological enmeshment between a parent and a child. We could be talking about parentification of a child, adultification of a child, or infantilization of the child. And parentification, adultification, and infantilization are different kinds of enmeshment dynamics that could be present between a family or between a parent and a child. Let's talk about each of them. The common denominator of all these three is that the parent who is involved in this enmeshed dyad between the parent and the child has treated the child in an age inappropriate and culturally inappropriate manner. So in a normative relationship, we have healthy boundaries between parents and children. In these enmeshed relationships, you see a gradual and steady erasure of those boundaries. So for example, let's say mom and dad are going through a high conflict, really contentious divorce. There's a lot of litigation going on. The child happens to be a teenager, and dad starts confiding in the child about how mom's affair led to the divorce, how mom is the reason for the family's breakup, how mom chose to move out and leave us alone. And that us becomes important because the child starts being aligned with the father in some sort of a tribal warfare, us versus her. And I'm just giving an example, the genders could be reversed as well. So the child gets privy to some information that is not appropriate for the child to be burdened with. And that could be a dynamic of adultification. In parentification, you see a role reversal or a role corruption, where the child starts getting worried about the parent's health. Is mom eating when I'm with dad? Has mom remembered to take her medication? Is mom going to be lonely if I spend time with my dad on the weekends? What must be she doing? The child keeps on checking on the parent. So that's something that is going into the unhealthy dynamics right there. But it's also helpful to note that there are two kinds of parentification: instrumental and emotional. In instrumental parentification, you see the child taking on some particular activities that is sort of transactional in nature. You know, in immigration or immigrant families, you often see the child as a translator. Mom or dad doesn't speak English well, the child speaks Spanish and English, and the child is there to translate what's going on. And that is a form of parentification, but we are not worried about it because it's transactional. I mean, once that transaction is done, the kid goes back to being a kid, and the parent-child hierarchy is maintained. But in emotional parentification, that hierarchy is slowly erased. And we see those problems coming up in courts. And that's not alienation, but it's considered to be psychological maltreatment depending on the severity of it. And it needs intervention. It needs something that may appear to be counterintuitive. For example, if the relationship between the mother and the daughter is enmeshed, and the daughter is unable to have an identity of her own, thoughts of her own, impressions of her own, and is completely subsumed with the mother's impressions and belief system, on a superficial level, you could see that they appear to be very close, very bonded. But what is required is that the child is demoted to the level of being a child. And the mom gets some tools, psychoeducational tools, to deal with this enmeshed behavior and enmeshed system. And the child gets to spend more time with the other parent who has healthier parenting behavior. So more time with dad. I mean, it appears counterintuitive because you would think, why on earth would we separate these two? They appear to be so close. They're super bonded. They finish each other's sentences. They dress alike. They have pictures on the social media of having fun together. Mom says, well, she's not my daughter. She's more like a friend to me. And those are some warning signs.
Yeah, and I think that a lot of people can kind of dismiss those warning signs. It's like, oh, that's so cute, right? Like the child is dressing like their parent. The child is, picking up the mannerisms of their parent. And, I think a lot about the fact that I'm slowly turning into my mother as I get older. But obviously that's a completely different dynamic than what we're talking about when we're talking about parental alienation. You've mentioned a couple times, high conflict cases. And obviously, as someone who works in appeals, I'm very familiar with a high conflict case. Not every high conflict case has parental alienation, correct? There's a difference between the two. Where do you kind of see the role of an attorney in terms of identifying a high conflict case versus a parental alienation case? And I do just want to say before you answer, I am seeing the questions in the chat. Some of them are going to be answered by the other questions that I have later in my outline. So please continue to be patient.
In my opinion, a case that involves moderate to severe parental alienating behaviors is by definition not a high conflict case. And let me explain why. When we use the term high conflict, there is an assumption that the conflict is mutual, that dad and mom are simply at loggerheads. They are not able to get along with each other. They both have their weaknesses. They both have, like, stubbornness and whatnot. So that dynamic is different from a case involving severe alienating behaviors, because what you have in the latter situation is a case involving child abuse. In that situation, you have parent A who has demonstrated this severe alienating behaviors, which are causing the child to reject and resist parent B. And the targeted parent, parent B, is trying to fight against that abuse. There's a lot of frustration, there's a lot of outrage on the rejected parent part, there's a lot of anger as well. But that parent is reacting to this abusive behavior and trying to get help. So that is not high conflict. That is a part of family violence issue that needs to be taken care of. So you would not say that's a high conflict case because parent B must have done something to deserve this kind of treatment from the child. You can't make that assumption. But on the same by the same token, if there are findings made by, let's say, child protective services or by courts or by custody evaluators that parent B has demonstrated abusive behavior, neglect, and all of that, then you might not want to rush to the term parental alienation. And it could be a situation, could be hybrid. It could be a situation that could be estrangement as well. So you need to take a look at it. But often we just put a label of high conflict prematurely, and that may not be helpful because it assumes the mutual bad behavior.
Right. And part of what you said kind of resonates with me, and it ties into my next question that I have for you, which is, I see a lot of the time where my clients are very frustrated with the judicial system, and understandably so, because they have a judge who maybe isn't taking their allegations seriously, maybe isn't, intervening when the judge should be. And when we label a case high conflict from the start, it's easy in my mind for judges to kind of tune those cases out because they know, oh, well, this is just, the Smith case. It's up here every 2 months on the same issue, right? It's up here because dad is manipulating the child against mom, let's say. How do we kind of get judges to take these issues more seriously? What can we as attorneys do to help our clients if they find themselves in a situation where they are, their child is being alienated from them?
Wow, I mean, lots to unpack there.
I'm sorry, it was also kind of a compound question. So
That's okay. I mean, so let's try to break that down. I think as lawyers, well, first of all, we need to understand that we need to have boundaries between ourselves and the clients. I've seen plenty of lawyers cross those boundaries and start acting as therapists, start acting as parenting coaches, start giving parenting advice. You know what? If my daughter were to say that to me, here's what I would do. And here's what you should be doing with your son when the son does this and that. So no, let's stay in our roles, let's stay in our boundaries. If there is a need for a parenting coach, advise the client to get a parenting coach or try to think about a good coach who could be helping out in the situation. But parents need to understand that their behavior is being noted by the children. So if you're expecting the children to follow court orders and act appropriately and with respect towards a judge, towards a professional, towards the parent, that starts at home. I mean, often in good family systems approach counseling, you would find out that the parent says all the right words in front of the therapist or in front of the guardian ad litem or sometimes even the court, but the child just doesn't buy that. And that happens because the moment the parent and the child get back in the car and go home, the parent does the same thing, denigrate the other parent, disrespect the court system, denigrate the professionals. So the kid gets the message that, well, mom or dad, when they say these good things about the other parent in therapy, it's not really, it doesn't really matter. It's not the real thing. So that's one part of it. Early psychoeducational tools do help if the parents are doing it in good faith. But in talking about the judges and the court intervention, I think it is critically important to focus the court's attention on the behaviors. Forget about the labels, forget about parental alienation, estrangement, forget about psychobabble. If there is a particular pattern of behavior that is causing an issue, you have repeated bad behavior from, let's say, parent A, which is denigrating the other parent. It happened in front of school teachers, it had happened in front of therapists, it had happened in front of pediatrician, family members. That behavior needs to stop. At the end of the day, the courts are not going to do anything about someone's belief system, but they can do something to contain bad behavior. The moment bad behavior starts having accountability and consequences, that's when the change happens. So let's focus on the bad behavior and let's talk about, judge, this is what's going on, this needs to stop. What at times ends up happening, Jordan, is that parent A talks about bad behavior, but then puts it all under the umbrella of parental alienation. Parent B says, no, no, that's not bad behavior. I'm trying to protect the child. Parent A is just a bad parent. He's abusive. She's abusive. And I'm being the protective parent, and it's not alienation, another label, estrangement. It's legitimate, justified rejection by the child because the parent A doesn't know how to be a parent. And in back and forth, the lawyers start making deals in the hallway. They start making some arrangements. The goal, which is considered to be a noble, laudable goal, is to avoid litigation. And they pick a therapist that they trust, and everyone is shunted off to therapy without there being any findings, any judicial findings or forensic findings made as to what really was the issue. And you see this dynamic play out for 9 months, 10 months, 1 year. And when it goes to litigation, the case is far more toxic. So if there are allegations of alienating behaviors, or if there are allegations of a parent being abusive parent or demonstrating suboptimal parenting, let's have findings of fact made. We should not be shying away from evidentiary hearings, but rather we should embrace them and ask the court to make a finding of fact. Because if you have a finding of fact, then you get proper treatment, you get proper therapy. Imagine a situation where a therapist is given a court order saying that mom is safe, loving, fit parent. Dad has engaged in some behaviors that has caused the child to believe the mom is unsafe. This belief has no foundation in reality. Now the therapist knows what to treat. Or the court order says the daughter has been resistant towards the father. The father has engaged in deficient parenting. The father has been insensitive. The father lacks empathy. And we need to work on the relationship. Now the therapist knows what's given to the therapist to work on. So I think these findings matter. And the sooner we get these findings, the better off the family will be.
Yeah, and you and I kind of talked a little bit before this kind of in that arena, and we talked about how that's very much almost the opposite sometimes of what attorneys think. Attorneys often go in and think that they can solve everything just if everybody just agrees. But in reality, sometimes it's better, and especially in the case of a situation where we might have alienation, we might have estrangement, no matter what the labels are, we've got some bad behaviors going on. It'll be better off, everyone will be better off if we have findings that are actually made so we can kind of direct the therapy, because it doesn't help anybody to throw therapy at it for 6 months and then come back and everything is still exactly the same as it was, only worse at that point. One of the questions that is kind of very specific, you had mentioned a parenting coach. One of the participants has asked, what is a parenting coach and what training do they have?
That's a great question. And it's, again, somewhat of a nebulous term because, to my knowledge and understanding, there is no specific credential training to be a parenting coach. But generally speaking, they happen to be mental health licensed professionals. So they could be a psychologist, they could be a social worker, they could be a licensed marriage and family therapist, but they engage with the parent who is going through some tough litigation or tough issues in terms of child rejecting a parent, or what is known in the field as resist refuse dynamics. And the parenting coach is helpful because there is a resource that a parent can avail of. So let me give you a typical example. Dad has parenting time coming up in the weekend. Dad gets a text from the child saying, I don't want to see you this weekend. I have stuff to do with my friends, or I'm going out with mom on a weekend trip or whatnot. Dad continues to text back, no, it's my time. I have plans for us. And the child says no. And that text message back and forth spirals from there to name calling, denigration, disrespectful behavior. And all of a sudden, you have allegation of controlling behavior, abusive behavior, authoritarian parent, ex parte emotions, a therapist sending a letter of all those things. A good parenting coach can help a parent to respond to those exigencies. That's not the lawyer's job. That's a job of a coach. Or you are going through a really contentious child custody evaluation assessment. A good parenting coach would help you understand the dynamics. What's involved here? What can you expect in an interview when you are meeting with the evaluator? What sort of testing is done? How to address some situations that are coming up with your teenagers. I mean, some of the problems that we see is that the divorce and separation is going on for a long time, and the children are also growing up during this time. So, what may have been a decent, good parenting style for a 12-year-old may no longer be the case for a 15-year-old or a 14-year-old, especially if the parent has less and less time with their kids. So, a parenting coach helps the parent navigate through this lot of situations.
And that's something that, I personally at least haven't really heard discussed anywhere in terms of how we can kind of boots on the ground deal with this sort of phenomenon of parental alienation, right? Is so maybe bringing in an outside professional who can only focus on the actual parenting. We've had a couple questions in the chat and in the Q&A, and it's also ties into one of my questions, just kind of, I don't want to call them general practice questions, but how do we, first of all, if the only evidence we have of parental alienation is what this is just what the kids are telling me, right? This is what my kid is saying that dad says these things. How do we kind of get that to the court in the best way possible? And sort of related to that, what is there anything that we as attorneys can do kind of immediately when our clients bring us these types of situations that can, I don't know, maybe help the situation, help avoid litigation? I know we're talking about not avoiding litigation, but in terms of immediate relief that we can kind of give to our clients, are there any referrals or anything like that that we can make for them? And again, I know that's a very long and complicated question. So you can
Yes,
take your time if you need time to answer it.
there are several things that could be done depending on the ages of the children and where the case is at. If it's a case involving mild rejection by the child or mild behaviors, where the kid's still respecting the parental authority, still calling dad, dad, mom, mom, but there are some conflicts back and forth. The ideal thing, or the one of the good things to think about, is a good family systems counseling for the entire family. We are not talking about individual counseling or individual therapy because that could make it worse at times. But we are talking about family counseling or joint counseling, where the counselor has the entire family as a client, and the counselor, who is trained in the family systems approach, works with the child, works with dad and mom, and combinations of the family together to address these issues. That's one approach. The second approach is trying to see if a guardian ad litem would be helpful. Not a lawyer guardian ad litem, but a guardian ad litem, because you don't want to hand over a lawyer to the child and say, now he or she is your lawyer, and he or she will do exactly what you tell them to do. That's LGL, and that could make again situation worse. But a guardian ad litem could be tasked with looking at the dynamics and see what's going on, could interview the child, and then finally advise the court about what's going on, file a report, and all of that. But it's also important to try to do some diligence before agreeing to a GL to make sure that the GL you have in mind has some understanding of a child alignment situation, alienation dynamics, estrangement dynamics, and more importantly, is not going to end up over empowering the child. One of the worst things that I've seen in this case is, and this is across the country internationally, not just Michigan, is we seem to have situations of legalized lawlessness. And by that, I mean that a child who is 14, 15 years old tells everyone, I'm not going to follow court orders. I don't care what the judge says. I'm not going to go on parenting time. And the lawyers basically wring their hands. And sometimes the guardian ad litem goes to the court and say, Judge, the kid's not going to agree to this. What are we going to do? And then the judges start backpedaling and say, well, we are not going to pass orders if the kid's going to refuse to follow them. And that is concerning because that is a kind of psychological maltreatment. If you look at the literature in the field, one of the psychological maltreatments is to encourage or model antisocial behavior for a child. And you are modeling as a parent antisocial behavior by giving the child an understanding that laws are for other people to follow. And somehow the kid is above the law and doesn't need to follow the court orders. So a good GL will make sure the child has a voice, that voice is respected, the voice is heard, but the child doesn't end up getting a choice. The child doesn't get to be in the driving seat and start telling people which orders are okay or which orders are not okay for the child. Because that's a slippery slope to a toxic disaster and more litigation down the road. If there are allegations that the parenting time is genuinely not helpful, and if there are allegations that the parent uh, who is losing out on parenting time is really abusive or is demonstrating some concerns, let's have a hearing. Let's make some findings of fact and modify parenting time. But to pretend that these parenting time orders are just for the sake of orders and not going to be followed, that I think is a recipe for disaster.
Yeah, and I think we see that quite often, especially with older children, as you mentioned, right? We've got 15, 16, maybe even 17-year-olds who are just deciding that they don't want to follow court orders. And I think that also kind of goes back to what we were talking about earlier about how this all kind of starts with the parents. So if we're encouraging our clients to follow the court orders, they should also be encouraging their children to follow the court orders, right? If it's a healthy family, parent, child dynamic, that's what that looks like. And
I have seen the judges who are able to make a difference, the judges who have control of these cases, who stop these cases from getting toxic, are those who intervene early on. At the first sign of violation of court orders, the judge should call the parties and the counsel and say, this is not going to continue. Parent A, if you are unable to make your child follow the court orders and have the child go on parenting time, then maybe something is wrong here. Every weekend that is missed by parent B is going to result into immediate makeup parenting time, automatic parenting time. There are going to be sanctions involved. Or if there are 3 or 4 more violations in a row, we are going to have a larger hearing, possibly thinking about changing of custody. Because if you can't really teach your child how to abide with lawfully passed court orders, how to respect the other parent, how to comply with parenting decisions and the court's decisions, then maybe you shouldn't be the one holding custody. Maybe the other parent should get a chance to teach this to the child. And again, we need to make the findings, because if there are genuine concerns about why the kid should not go on parenting time, let's get those findings made.
Yeah. And you kind of mentioned this a little bit, but is there more that we can be doing to kind of prevent, or at least try to kind of prevent alienation? I know that we talked a little bit about how maybe just straight punitive approach doesn't necessarily work, but is there something that we can be doing to help our clients in these sorts of situations to prevent it from getting to the point where we're talking about alienation, where we're talking about estrangement?
Yes, again, having a good parenting coach, for example, would help. Uh, Using some good psychoeducational tools. One video that comes to my mind is Welcome Home Pluto. It's a documentary film made by Dr. Richard Warshak, which explains the alienation dynamic. It doesn't involve like blaming anyone, but it shows how these alienating behaviors could really harm a child. And it explains what is considered to be an alienating behaviors. And there's animation in it. So depending on the ages of the children involved, watching such a movie would be helpful. But it's basically having the parents understand that your behavior, verbal and non-verbal, is being watched by your children. Kids are watching you. So when you are frustrated and exasperated by something that was filed by the other side, and you start sharing those details with the kid, or you lay out those court papers on the dining table for the kids to read and go through, it's going to cause some significant issues down the road. So just proper role modeling and expecting adults to be adults is the starting point.
I'm kind of monitoring, lots of questions coming through, so I'm monitoring this. One of the questions that was asked was the name of that movie, and it was Welcome Home Pluto, right, by Dr. Richard Warshak.
Yes, I mean, let me double check. I have it somewhere here.
While Ashish is looking for that, I'm gonna go back to kind of an earlier question that was asked about hearsay when we're talking about the statements of the child. I might be able to answer this one. I've seen it in
You see
cases
this?
where, yes.
It's Welcome Back, Pluto.
Welcome back, Pluto. Okay. I've seen it in cases where attorneys have gotten the statements of the child in as not hearsay because the statements are not being used to prove the truth of the matter asserted in the statement. Right? We're not offering the statement to prove that, dad is bad or mom is bad, those sorts of things. That's one way that I've seen attorneys get statements of children in when we're talking about an alienation case, particularly when we're not necessarily just talking about the actual alienation that's going on, but when we're talking about these are the statements, this is how we know this is happening, because the child is saying that dad's food is bad when there's no evidence of that to back it up. So we're not offering the statement to prove that dad's food is bad. We're offering the statement as not hearsay. It's what, that is what it is. So
Well, the food could be bad, Jordan.
I don't know, Dad. I
Anyways, I
can't
mean,
attest to
jokes.
whether or not his food
Yeah,
is good.
I mean, jokes apart. Some of the cases that were litigated and resulted in appellate opinions, the courts go into detail about what alienating behaviors the court found to be really troublesome. And some of those behaviors are text messages between a parent and a child. So, for example, in the one of the cases out of Tennessee Court of Appeals, McLean versus McLean, the father who was an alienating parent in that case, or found to be an alienating parent, continuously told everyone that he really wants the son to have a decent relationship with the mother. He really is hopeful and desirous, and nothing could please him more. While he was saying these good words to professionals, the text messages revealed when they were finally obtained that he told the son that your mother is mentally ill, your mother is an adulteress, or the Bible hates her, she has done wrong in the eyes of God, no one will ever like her, nor should you. These are really horrific text messages that he kept on sending his son during the time the kid was with the mom at times. So when these surfaced, the court instantly found that the father had zero credibility. And nothing is going to work as long as the kid continues to go back in that poisonous environment with the father. No therapy is going to work 2 hours a week if the rest of the time is spent with this parent who continues to poison the well. So you have to look at evidence and from a totality standpoint, that if a parent is telling folks that I am doing everything in my power to help the child and the other parent, is that genuine? Is that credible? Or is that just for the show of the litigation?
Looking at a couple questions here. I've had a
Can
couple
can I
questions.
address something else that often comes up?
Of course, go ahead.
Sometimes what happens is that instead of focusing on behaviors, instead of the focus being on conduct or actions which are measurable, which can be proved, and all of that, lawyers in the courts get distracted about theories. And all of a sudden you are in like litigation trying to prove that parental alienation syndrome is real, or parental alienation syndrome is a hoax, and no one could mention the term parental alienation, and the science and the papers are being flouted and thrown around from both sides. And these times, I mean, this is problematic because you are losing precious time which could be engaged in for proper mental health and legal intervention. But there is also a tremendous amount of misinformation out there regarding parental alienation theory. And one of the pieces of misinformation is a research paper that claims that judges change custody at the drop of the hat the moment parental alienation is mentioned. And they ignore claims of domestic violence and they ignore claims of abuse. Now, this goes back to the paper that was written by Professor Joan Meyer and her colleagues. If you read that paper, and many times I've found that lawyers talk about this paper without having actually read it, and so do the experts. But like any piece of social sciences research, the paper has disclaimers and limitations that it talks about. And one of the disclaimer that the authors of this paper put out is that they could not, and they did not, review the facts or assess the court decisions where the judges had rejected claims of abuse. So, for example, they look at a case and they found that let's say parent A had alleged domestic abuse, which the court rejected, and the court instead found alienation. Now, they took that as an example that the moment alienation claim was made, domestic abuse lost out. It's important to know why. It's important to know what that trial judge did in that situation. It's important to know whether the claims of abuse were not credible, why the judge found them to be not credible. There's a difference between an allegation and a finding. And that's why it's important to go down deeper on this and find out what exactly is the situation here. Because, of course, there are false allegations of parental alienation. There are false allegations of domestic violence. There are false allegations about psychological maltreatment. There are false allegations about alcohol abuse, substance abuse, all of it. That's why the courts are the triers of fact. And that's why we need the findings of facts made. Otherwise, these ghosts of allegations just keep on chasing the family around for years at a time.
Yeah, I mean, it's an excellent point. And part of my takeaway is that, as attorneys, sometimes we do get caught up in the labels. I know that personally, I'm trying to move away from using terms of art. And I think that the one case that I'm thinking of, the published case in Michigan, the Martin v. Martin case, where it has that very important footnote about it doesn't really matter whether or not parental alienation syndrome exists. What matters is the behavior on the part of the parent. And I'm trying to, at least in my own practice, move away from this is obviously parental alienation. This is obviously estrangement. This is, obvious. No matter what the term is, the problem is what's happening and the behavior that's happening. And I know that one of the questions earlier, I can't remember the exact wording, was how we can kind of help alienating parents, right? So the parent who is actually doing the alienation, how do we help them kind of realize the long-lasting harm that they are doing to their child by, perpetuating this alienation on them? And I know that the consequences of alienation for a child can be severe in terms of stunting their development, their emotional development, those sorts of things. So if you just want to kind of expand on that a little bit, well, we've got our last 15 minutes here, so I can keep looking at more questions.
Well, there are a lot of ways. There's a lot of research out there which you can share with a parent who you think has engaged in alienating behaviors. But at the end of the day, it depends upon the parent's good faith. Is the parent genuinely concerned about the child? Is the parent genuinely desirous of the child having a decent relationship and a good relationship with both parents? Are they willing to work together? Are they willing to own up to some bad behavior? I mean, there's tremendous power in the power of genuine apology, but people shy away from it. There's a great chapter written by the former judge from Chicago, Michelle Lawrence, in a book, International Handbook of Parental Alienation. And she wrote the chapter with the title Judicial Perspectives on Parental Alienation. And she mentions how, in her 17 or 18 years on the bench as the domestic relations judge, what she found was that giving little speeches from the bench doesn't help. To keep on telling a parent who has demonstrated alienating behaviors how harmful they are to the child really doesn't help the situation in most cases, because the parent is caught up in some really distorted reality and has a really distorted perception of the other parent, who that parent believes to be abusive. So you may be looking at some undiagnosed personality disorders. You may be looking at some trauma that is unresolved for a long time. So in these situations, it's best to let the mental health professionals deal with those dynamics, but seek accountability at the same time. So we could agree on counseling, but we could also agree that parenting time orders will be honored and complied with. We can also agree that the court will have a review hearing, let's say every 90 days, could be a short review hearing to make sure there are no ongoing violations of court orders. The parenting times and the sessions are being maintained. The family coaching and the family systems counseling that was put into place is being continued, and everyone's going and participating in good faith. So you have people moving in the right direction together. What causes these cases to get really crazy and toxic is the parenting coordinator or counselor appointed by the court is trying to push in one direction, and an individual therapist for the child who is completely cut off from the other parent and is siloed off has a completely different approach and keeps on pushing in direction B. And that tears the family apart. So there has to be an understanding as to what intervention we're going to put in place, and more importantly, why, which goes back to my first point. Let's make some findings of facts here.
If added all of your criticisms and you learn nothing else, it's that we need findings of fact in these sorts of situations, because otherwise we can't do anything. My last kind of a question that I had prepared for you before this was, do you have any suggestions in terms of resources that attorneys can go to, parents can go to? Now, I'm not going to ask you like, give me your list of names of professionals, Ashish, but just kind of generally, things that attorneys can be using, that they can be offering to their clients, those sorts of things.
Well, there are some good books, but I'm hesitating a little, because if you have a client who comes to you and claims that he or she is being alienated, and you hand out a book on alienation, that may or may not be the right thing, because it may be a different case. So before validating a client's image of a label being accurate or not, I think lawyers should do some diligence, and the lawyers should look at the cases. I mean, I've found in many cases where the clients come in, for example, and have diagnosed their case as parental alienation, And when you look at the CPS reports and you look at the mental health reports and look at some evidence, you have to break it to them. Well, no, it's not alienation really. This is something else going on. So if the client seems to have a wrong image or the wrong perception in mind of a psychological dynamic, let's ensure that that's corrected. And that's where a good parenting coach could be helpful so that the lawyer has access to a mental health professional in doing this. But there are, for lawyers and professionals, I think some of the good research that has come out in the past 10 years is from the AFCC, which is a really good organization that have peer-reviewed publications. They have a lot of CLE programs, webinars. So the more you go out of your comfort zone and you engage with professionals, especially multidisciplinary teams where you have a psychologist working with a lawyer or a social worker, a psychiatrist, you get to learn more. You get to have exchange of ideas. American Bar Association's section of family law is helpful as well. Uh, go out on CLEs and talk about these things and just interact with professionals.
Okay, well, that was kind of the end of my prepared questions. So I'm just gonna go through and make sure we answered all the ones in the chat. One of the questions that was asked was whether you know of any authority to require parents in a high conflict case with minor children to participate in joint counseling together. That I read as the parents participating together potentially, maybe participating with the children. I know that at least kind of the answer to it is, well, we're not just going to force people into therapy until we know exactly what's going on. I know that's obviously one of your big takeaways, but your thoughts on whether or not there's any authority to require it outside of just the judge saying, I'm requiring it.
Well, I can't seem to recall a statute off the top of my head, but I think the court has discretionary authority to order family counseling in the overarching best interest of the child standard. If there are continued bad behaviors, for example, let's say you have a case of a parent having engaged in alcohol or substance abuse. You have evidence of DUIs, you have evidence of bad behavior, you have evidence of the parent being drunk on occasions, flipping out. The courts don't hesitate to suspend that parenting time and order supervised parenting time until the parent goes to a rehab facility or comes clean and does testing. Why should psychological abusive behavior treated in a different way? If you have evidence that a parent has been engaging in behavior that is problematic, the parent needs help, the child needs help. And the court can absolutely order family counseling. If the parent refuses to go to family counseling based on some claims, then let's have an evidentiary hearing because the parenting time may need to be suspended. Or there may be some safeguards that need to be put in place of supervised parenting time. I do agree with the notion that therapy for the sake of therapy doesn't really help unless you know what the issues are, which again goes back to let's get the findings made.
Mm-hmm. Kind of some related questions here. Is whether alienation can be inferred simply because the parent won't follow the parenting time order, and alienating behaviors that are more subtle. I know that we're trying to, I at least personally would stay away from labels, right? We're going to talk more about the behaviors. So if we've got behaviors that are more subtle, like, or we only have that a parent won't follow a parenting time order, what's the best approach with those sorts of things? If we're talking about from the perspective of, is this alienation, is this not?
Well, the parent not following the court orders may or may not be alienating behavior. I mean, certainly a bad behavior. It's for example, a parent who refuses to take the child to regular medical appointments, that's evidence of neglect. It's bad parenting. It's modeling antisocial behavior for the child as well. So those things need to be addressed. You don't need the label of alienating behavior on that. That simply tells the court that parent A, who refuses to follow court orders, can't be trusted with. And maybe parent B needs the decision-making capacity and custody and more parenting time so that the parent B can role model the proper behavior for the child.
What about situations where there's been domestic violence between the parents, right? So if we're talking about we need to get this family into family counseling, Is that something where potentially we could maybe involve another therapist to work with the fact that this is a DV case, right? We do have kind of this underlying tone of the power and control dynamic with, you know, people who have suffered abuse and their abusers, those sorts of problems.
Yes. So if you have evidence or claims of domestic violence, and those claims have been substantiated by the protective services or courts, then you need to tread with caution, because a victim who has been a victim of domestic violence, which could also include coercively controlling behaviors, you don't want to put that person in family counseling with the abusive person, because then that counseling could be used as a further controlling mechanism. You see all this all the time in coercive controlling behaviors, where the controller continues to want to engage, continues to want the victim to engage with him or her, and that counseling is then seen as a continuation of abuse. So you need to first focus on what's going on. And again, let's make findings. If there are no findings by the protective services, if the claims of domestic violence are unsubstantiated, let's have a short evidentiary hearing where the parent who claims to have been gone through abuse or controlling behaviors can testify, is subject to some cross-examination, so the judge can decide what sort of controlling behaviors is a parent complaining of. You can't just assume that because a parent A is making allegations of abuse, there being no findings, it must be true. Let's take it as true, because then you're looking at a parent B and treating that parent as an abusive parent without any findings or evidence. And that's not right either. Apart from the problematic due process violation, you're also sending a message to the child that because that parent can't see the kid, or because there's no therapy, is because dad or mom has been found to be abusive.
I know that I mentioned it briefly in the beginning, but Caden's Law, I know that you just recently wrote an article on it. I don't know if you wanted to just quickly summarize it in our last few minutes. I know it's a long article. I did read it. It was
It's a long article. I think
yeah.
law, the intention is absolutely something that I agree with, to protect the children from abuse, all kinds of abuse. However, in my opinion, the article, rather the law, goes too far in tying the judge's hands and family court's discretion. It bans particular kinds of treatment and particular kinds of reunification programs that could be necessary in some situations. So, for example, to tell a court that regardless of evidence in front of you, regardless of the fact situation in front of you, regardless of the necessity of such a program that might be involved for a family, you can't order this treatment, period. I think that's strong arming the family court, and that infantilizes the judges and treats them as if they don't know what's good for the family. And we are going to tell you here exactly what you can order and what you can't. That's my problem with Caden's Law and how it's written. And again, it's Caden's Law. The federal law is a funding law. The states have to pass their own laws to get the funding under Caden's Law. So in California, for example, you have Peaky's Law. Colorado has some else going on. But I have a problem with any law telling the court about a particular kind of mental health intervention to be problematic, or you can't do this treatment, you can't do that treatment. That's micromanaging the judiciary. I mean, for example, when the courts order therapy, generally speaking, how much thought is given to that label therapy? How much thought do the courts and the lawyers give before going off to therapy for the family? So you need to do diligence, you need to question some programs, you need to question the efficacy, you need to question the relevancy, all of that. But you can't write off certain kinds of treatment in an absolute manner.
Well, we are with that officially out of time. I don't know if you had any closing thoughts, Ashish, anything else you wanted to kind of get off your chest.
Now, these are all great questions. I hope it was helpful for everyone.
Yeah, well, and I know that a couple people have asked, and I see that one of the participants did answer this, but the recording will be made available to all of the registrants, as well as we do some takeaways as well, just kind of the key points. So that will be coming from our office. I just want to thank you, Ashish, so much for taking the time to chat with me today and being patient with my first time webinar hosting
Oh,
skills
you were
here.
great. You did wonderful. Thank you.
Yeah, of course. And I hope that everybody has a lovely afternoon. But with that, that is the conclusion of the webinar. Thank you all so much.
Thank you.